May please, Lordship, I beg to mention item number 3, Lordship. Lordship, today, engagement of LR model, yes, some partial degree, Lordship. Kindly, I don't know for today, Lordship.
Okay. What is your name?
A. Islam.
On the pair being made by Mr. A. Islam, learned counsel for the accused. Press this list the matter on when?
Any difference?
Okay.
On 28,
Sort that.
25,
Yes.
Yeah, Your Lordship, I beg to mention item number 5. Matter will be taken up for next week.
Why?
My senior suffering from health issue.
Suffering from?
Health issue.
Did you inform Mr. Dixit Gogoi, the respondent number 2, counsel for the respondent number 2? No. But you inform him.
Yes.
Miss, your good name?
M. Soikia.
Learned counsel. For the learned counsel appearing on behalf of Mr. M.U. Mahmood, learned counsel for the appellant. Price for listing the matter on
26 June,
26 June.
Yes.
As Mr. M.U. Mahmood, learned counsel on learned conducting counsel, Mr. M.U. Mahmood is suffering from illness. Here is accordingly allowed.
Obliged.
for motion, item number 1,
May please, Lordship.
Yes.
Anticipatory bail petition, my lord, and the FIR is at page number 22, my lord. FIR was lodged against my lord 5%, who are alleged to be practicing BDR without valid documents, my lord. I am not among the 5, your lordship.
Is this a first application
My
or
lord,
second application?
First, my lord.
First. Okay, let the city come.
The interim protection may be given. I will appear before the IO, my lord. I will submit all the documents. And one of the FIR request has been granted interim protection, my lord. I have annexed that order also, my lord. I am not an
Maybe.
FIR accused, my lord.
Maybe.
At page number 31, my lord.
Hmm. No, there was a ground for granting him the privilege of previous bail.
Here I am not practicing any VDS, my lord.
Pardon?
I have undergone a course under alternative medicine, my lord. I am now working as a helper of one Dr.
We will see
K.P.
for
Singh, my
the
lord.
case area.
My lord, then,
In that case, the person concerned has produced the original documents and his registration with the Dental Council of Maharashtra.
but I am
That's
not,
why bail was granted
my
to
lord,
him.
but I am not. My lord, then in this case, my lord, the CD is fixed on 21st of June, my lord.
21st of?
June.
Okay. The learned counsel for the applicant submits that fixing 21st of June, case diary of whose IPS? Whose IPS?
My lord,
Whose IPS case number
88/2024.
has already been called for by this court via in connection with AB number or BA number?
AB number, my lord.
AB number
1043/2024.
and as such, a pair is being made that on that day city may be perused to dispose of the present application also. Pair is accordingly allowed.
Right.
On that day, city will be perused to dispose of the present application also. Would it too hard? Yes.
for bail hearing, item 2,
May I please tell you? My lord, kindly see the FIR page 13, page 13, 14. And the operation.
This is first or second application?
First application. Page 15, my lord.
Page 15.
15 is the FIR. May I read my?
Yes.
With reference to the subject cited above, I have the honor to report you that as per daily routine checking and actions, Naka was placed at Naka checkpoint of Suraibari watch post on NH 8. The composition of the Naka was follows. SIUB Niranjan Das of Suraibari head constable, 4 persons, my lord. 4 police persons made a team. Then at around 1:30 p.m., red color six-wheeler Tata LPT 1109 container body truck bearing registration number AS01MC0376 coming from Guwahati side towards Tripura was arrived at the Naka checking point and the truck was stopped by the Naka party at the said place on NH8 for checking. The truck was driven by a person namely Mukesh Yadav, age 33 years, son of son, so and so, so and so. The time of routine checking, the backside door of the said truck was found unlocked. The on suspicions of the truck was thoroughly checked. During checking, total 8 numbers of cartons found containing escaped cough syrup, and accordingly, information was immediately reported by me to the officer in charge, Bazarisara PS, and superior officers about recovery of our mobile phone. During the spot interrogation, the accused driver of the said truck could not give any satisfactory reply. At about 5 p.m., I sought authorization letter for search and seizure. 5 p.m. I sought authorization letter search and seizure of the suspected and request items from CI, Ramkrishnagar Police Circles, X-ray, Deepak Das Inspector of Police, and I received the same at about 2:21 p.m. through WhatsApp message. After receiving the authorization letter, I served notice under Section 50 of NDPS Act to detain our driver and started to serve the narcotic substance about his right to be searched in presence of the independent witness. However, they could not be taken nearest magistrate or gazette officer for such as there was every likelihood that they would destroy the drugs and throw away which are suspected to be concealed in their vehicle. Such the whole process carried out in accordance with Section 50, subsection 5 NDPS Act of 100 CRPC. During investigation, the apprehended driver said that the owner of the seized vehicle, namely Santosh Kumar Mahato, who is in bail, minor, address New Guwahati, Rwanda, so and so, instructed his driver and sent him to loading the goods from godown of Gati KWA Changsari Guwahati. It is suspected that employee of Gati KWA Changsari Guwahati and owner of seized vehicle also directly involved in transportation of narcotic drug substances from other than places. It is noted that they committed offence jointly. Further, at the time of interrogations of the driver, the owner of the seized vehicle tried to contact with the driver by over mobile phone frequently. After completion of the search process, the said vehicle below mentioned articles items were recovered and seized. It is noted that the seized detained phosphate cough syrup were found without any challan inside the truck. The seized process was started at 4:50 p.m. One truck, red color, bearing so and so, then one registration number vehicle number S01MC0376 in the name of Santosh Kumar Mahato, son of so and so. Number 3, one driving license in the name of Mukesh Yadav. Number 4, total 1280 numbers of bottles of escape cough syrup, cotton phosphate cartons, each bottles containing cotton phosphate and 100 ml quantity of belonging to base number so and so. Conversion of cough syrup from volume to weight. Each of the escape cough syrup cotton bottles are similar in nature and contain total 100 ml per bottle. The chemical composition of cotton composition of each bottle is given as 110 mg per 5 ml. That is total 200 mg content cough syrup so and so. So my lord, gross weight of the one bottle containing 100 ml cough syrup is 130 mg. Weight, it is my lord commercial quantity. Next page, my lord. One Lava prepaid mobile phone, and number 6, one national permit, scan copy, vehicle number AS01MC0376 in the name of Santosh Kumar Mahato. Address so and so. Date of issue 3/2/2020 by public areas permit number NPGC 182/2020. Name and address of the witness are, my lord, Jiten Tantubai, 28 years, Bazarisara district, Karimganj, Anup Tantubai. And number 3, the police personnel UBC Prasenjit Sarkar. After completion of all these formalities, I along with my staff departed from the PO at about 7:02 p.m. and searched to the police station at about 8:35 p.m. along with inventory and other seized items and the apprehended persons. It may be mentioned that being the sub-inspector of police, I am empowered by the Governor of Assam by notification number so and so under the provisions of so and so authorization. I therefore request to register a case and take necessary actions. So this is the FIR. My first point, my lord, out of 3 independent witnesses, there are 2 independent witnesses, Caesar witness, Jiten Tantubai and Anup Tantubai. And as for the records, their statements were not recorded, my lord. I have not found their statements and recorded or not. However, their names were added in the charge sheet, but the statement is not found in the record. It is not recorded, my lord. Now, my lord, kindly see the charge sheet.
Yes.
My lord, kindly see the charge sheet, facts of the case. Page 26, my lord. Bottom, my lord. May I read?
Yes.
The prosecution history of the case of brief is that on 29/1/2023, informant SI Niranjan Das of IC Suraibari Sonso as had to the effect that White Suraibari WP GDA numbers 478 of 29 Jan 2023 at around 1:30 PM, he along with the company staff conducted Naka as daily routine checking, stopped one goods carrier truck as bearing number S01 MC 0376, which is coming from Guwahati towards Tripura, was stopped, checked thoroughly and found 1280 numbers of escape code, syrup code and based and 8 cartons. Accordingly, superior officer was informed, and in presence of independent witnesses, the suspected 1280 numbers but also cough syrups were seized as per procedure and apprehended. The accused person Mukesh Yadav also brought him to Bazarasira PS and arrested. Hence, the case was registered and investigated. During the course of investigation of the case, PO was
So, Mr.
visited.
Chaudhary, you are the driver of the truck.
I am the driver of the truck.
So from the truck driven by you, 120.
My lord, this truck, my lord, my ground,
Hmm.
this truck, I am the employee of Gotik EW. And there was
You are the employer?
Gotik EW. My lord, kindly see. May I read?
Hmm.
May I read, my lord?
Hmm.
Para, my lord, page number 4, para number 5.
So,
May I
so
read?
from that truck, 1,280 bottles of Exo cough syrup was recovered and seized.
Yes, my lord.
Hmm.
My
Now,
lord,
what is your case?
case, my lord, page number 4, my lord, para 5.
Hmm.
May I read, my lord?
Yes.
That the petitioner begs to state that the owner of the offended truck bearing registration number was owned by one Santosh Kumar Mahato.
Hmm.
The said Santosh Kumar Mahato was handed over this truck to one company having the business of express cargo pickup and delivery by way of service contract by instrument number 2476A dated 28/11/2022.
Hmm.
The contract period is 10/1/2023 to 10/1/2026.
Hmm.
The petitioner is the driver of the truck. He has no knowledge about the loading and unloading materials of the truck. He was appointed by the owner and being regulated by the company. The petitioner is having no liability over the carried materials. Under such circumstances, the embargo under Section 37 of the NDPS Act does not come upon the petitioner. This service contract is there. My lord, next page, para number 6, page number 5. That the petitioner begs to state that the Gotik Intensity Express Private Limited is a company incorporated under the Companies Act 1956, bearing CIN number so and so, and having its registered office at first floor, plot number 20, survey number 12, Katgula, Kondapur, Hyderabad, Telangana, so and so, India, having its zonal headquarters at Godsu, Guwahati. The company is in the business of express cargo pickup and delivery, logistic, and allied services through multi-modal carriage of cargo. Besides providing special service to the customers, including door pickup and door delivery of the consignment, etc., the petitioner is working under the control of the said company. The petitioner was appointed by the company after completion of all the formalities like verification of documents. He was sent to training and improving other skills, etc. Thereafter, the petitioner was engaged for assigned duties. As per the service contract dated 28/11/2022, executed between the Santosh Kumar Mahato vendor, Priyanka Devi guarantor, and the Gotik Intensity Express Private Limited Company, pursuant to the clause 38 surplus 1, the driver of the truck cannot be held liable during the course of employment. The said act also affirmed by the clause 18 and 20 of the service contract. Then para 7, that the petitioner begs to say that it is admitted that he was appointed by the owner and working under the control of the company. His duty is to deliver the consignments of the various goods of the said company to the consignee. During the course of seizing, the police recovered one national permit of the vehicle in the name of Santosh Kumar Mahato by public carrier permit number so and so. That the petitioner begs to state that the co-accused Santosh Kumar Mahato approached before the Honorable Court by way of anticipatory bail application number so and so, and this Honorable Court was pleased to grant bail by passing order dated 4/3/2024. On the strength of this order, had approached before the learned trial court, and the court released him by passing order dated so and so. Being the registered owner of the offended vehicle, Santosh Kumar Mahato had paid Zimma of vehicle. The learned trial court had given Zimma by passing order dated so and so. My lord, para 9, my lord. Page number 7. That the petitioner begs to state that since the prime accused of the owner of the truck was granted bail by this honorable court on the strength of the said developments, the petitioner approached before the Lanet trial court, but the court was not inclined to grant him bail by passing order dated
Okay,
25
we will see the AB number 3262 of 2023.
Yes.
What was the plea the owner of the truck had taken there?
Yes. Oh, my lord, kindly see similar order, page 7, para number 10, my lord. The similar order was passed.
Hmm.
uh, The 10 and 11, my lord.
Hmm.
The petitioner is working under the Karga company and doing works as per assignment of the company. He is not liable for the consignment loaded by the company. He is tasked to drive the vehicle.
No, that is a different
Yes,
case.
same issue, my lord. Kindly see, my lord.
No. We will see the AB number 3262 of 2023.
No, my lord.
What was the plea the owner of the truck had taken there?
My lord, para number 11, my lord. Similar coordinate benches pass granted bail in the same cases, my lord. Para 11, my lord. Petitioner begs to
No,
state
Millimeters was a peritive in that numbers.
you see, here the contraband substances were recovered from your possession.
my lord, kindly see para 68, page 68, my lord. In exam 9. One order is passed by the this honorable court.
Hmm.
May I read, my lord?
No, the
Different case.
Not different.
that
case.
case may be on
Same case.
different facts.
No, my lord. This
different
is also a
circumstances.
company. This is also a driver working under an logistic company, my lord. May I read, my lord, please? This is reported, my lord.
Hmm.
Mr. S. Mitra, learned counsel for the accused petitioner, contends that the accused is engaged as a truck driver by BRS Logistics Limited, which is the largest fleet owner of the commercial vehicle of India. Mr. Mitra further submits that as per the petitioner due to sheet and roster plane assigned by his employer company, he was assigned to drive the truck bearing registration number so-and-so from the transshipment point of the company at Gorchuk in Guwahati to Agartala. The goods loaded by the said truck consisted of the consignment of 10 cartons of mouthwash, which was booked by the consignor, namely so-and-so, Shanti Medical Agency so-and-so, in favor of the Bikash so-and-so, my lord. So, which were forwarded by one transshipment point to another transshipment point of multiple vehicles. The accused petitioner drove the particular truck only from Gorchuk point to Guwahati, at Guwahati to Agartala, and as such, he, who was merely discharging his duty, had no knowledge about the transportation of 10 cartons containing 3,000 bottles of codeine phosphate based Ascaf cough syrup along with other shipment items. Therefore, Mr. Mitra, learned counsel for the accused petitioner, vehemently contends that as the seized cough syrup contained 6 lakhs mg, that is 600 grams of codeine phosphate, the seized substances were less than the commercial quantity, and therefore the rigor section 37(1) and DPS sector are not attracted to this case. Opposing the bail application so and so, my lord. Now, court observed, my lord, next para, page number 70. A perusal of the case theory, it is revealed that 10 cartons containing 3,000 bottles of Pensitel cough syrups were recovered and seized from the truck bearing registration number so-and-so driven by the accused petitioner. The FSL report shows that a sample of Pensitel cough syrup gave positive test for codeine-based cough syrup and contained 186.5 ml per bottle. It further transpires that the accused petitioner is the driver of the truck via a logistic, and it is his duty to deliver the consignment of various goods loaded by the said company to the consignee as per Chalan. After thorough investigation, the investigation officer in his note dated 17/2022 noted that the seized cartons board sealed and packed by BR Logistic Company and loaded for transportation by the company truck driven by the accused petitioner for delivery. It has been further noted that the narcotic suppliers peddlers misuse the vehicles for VRL Logistic to fulfill their malicious intent, which were just carried by the accused driver. These findings of the investigation officer is, of course, subject to final outcome of the investigation. Therefore, this court is prima facie opined that rigors of section 37 of NDPS Act are not attracted in the peculiar backdrop of facts and circumstances concerning the present accused petitioner. For the above,
No,
sta-
in that case, the contraband substances recovered from his possession is not a commercial quantity.
no commercial
Therefore,
quantity, my lord, 3,000 bottle, and here, my lord, 1,280 bottles. My bottles were less than that quantity.
Hmm.
It was a commercial quantity. It was the submission of the learned council that it may be not a commercial quantity, but admittedly it is a commercial quantity.
So, okay, we'll see let
So-
the other bail application, we'll call for the bail application,
My lord,
anticipated bail application.
my submission is that, my lord,
Hmm.
I am covered under clause 18 and 20 of the service contract. May I read, my lord, the page number? Kindly see this, my service contract.
No, that was that was prepared by you people. No?
No, my lord, this is
Where is the legal sanctity of
this is
those
a notarized document, my lord.
maybe notarized document, is there any value?
My lord, on the basis of that, my lord, and this business is going on. My lord, kindly see page number
Maybe,
33.
we are not supposed to look after how the business is going on. We are to see your culpability.
My submission, my lord,
Hmm.
I am, my lord, my liability to drive the vehicle. I have no liability what is loaded in the vehicle, my lord.
Hmm.
And my lord, another thing is that two independent witnesses were not statements were not recorded. I have not found in the
No, the,
record.
That may not be come, Lordship,
Yes, ma'am.
but their name has been
No,
sent as a witnesses, Lordship. That in scan copy we have received, Lordship. In scan copy that their statements may not be come,
no,
Lordship. You cannot say, Lordship.
is there any mandate for recording their statement? Under which provision?
provision, my lord,
Huh?
whether, my
You
lord,
see 161 CRPC? What is there? The IO may reduce it to writing. He may not reduce it to writing also. Then,
so my lord, my case is covered under that page 33.
Hmm.
I am the working under Gauti company.
Hmm.
I have no knowledge about the what is loaded in the company. I
Hmm.
was instructed to drive the vehicle. Accordingly, I am the employee of the company. Training was given.
No,
So-
that aspect has to be considered during trial. At this stage, we are concerned with only the prima facie case. Here, the contraband substances were recovered from the vehicle driven by you. So you are the first person to answer it.
Vehicle is not controlled by me, my lord.
Hmm.
I'm just a driver. Vehicle is controlled by the company. The materials loaded by the company, my lord. I have no hand over that the materials which was loaded in the vehicle, my lord. My submission is that whether being a driver, what I have no knowledge and no, I have
Okay, we'll
My-
see.
my
First, Mr.
simple
Esther
submission.
Chaudhary, learned counsel for the accused, and Mr. P.S. Loco, learned additional PP for the state respondent. At the time of hearing, Mr. Chaudhary, learned counsel for the accused, submits that the owner of the truck has already been granted the privilege of PRS bail by this court by order dated 4/3/2024 in AB number 3262 of 2023. And that the present accused is also stands in the same footing. And therefore, Mr. Chaudhary contended that the same privilege may be extended to the present accused also. No, present accused also. In order to appreciate the submission of Mr. Chaudhary, learned counsel for the accused, perusal of the record of AB number 3262 of 2023 is found to be necessary. And accordingly, it is provided that Registrar shall take the AB number 3262 of 2023 along with this record and place the same before this court on Tuesday,
On 18.
My lord, 18, on 19, my lord.
19.
19.
Okay.
Published.
Number 8.
Yes, Mr. Grover.
Lordship, this is the second bail edition, Lordship. Yeah, Lordship, out of 11 witness 7 are already examined, Lordship. Examined witness, no, nothing is stated against the present petitioner, Lordship.
Have you gone through the record?
Last
No.
occasion we have gone through, Lordship.
Pardon?
On last occasion, we have gone through it. I just have to go to.
Okay, after some time, then.
Lordship,
Next item.
Item number 4,
For lordship, in this case, was Sarsit file lordship, CS file lordship.
You were on interim?
how many interim lordships? They did before the IO lordship, the exception has been recorded lordships.
You were not on interim.
How many interim lordships?
You were on interim.
Lordship.
So what is the Sarsit number?
CS number lordship 28/24, dated 29/3/24. In section में लिख ली बोली.
29/3/2024. What are the sections?
That's I have given.
Lordships. Sections lordships under section 379. Or
In the same section in which the case was registered. Heard Mr. T. Sutia, learned counsel for the applicant, and also heard Mr. Locker, learned additional PP for the state respondent. Apprehending arrest in connection with Khatri PS case number 8 of 2024 under section 379, 411, 34 IPC, dated with section 11(1)(a), D, E of the Prevention of Cruelty to Animal Act 1960.
ABE
Read with section 13(1)(16)
16.
of the Assam Cattle Preservation within Wicked Amendment Act 2021. This application under section 438 services papered by two applicants, namely Mohammad Habibur Rahman and Mohammad Moin Ashraf, for grant of PSP. It is to be noted here that above noted case has been registered on the basis of the FIR lost by one. Where is the FIR?
lordship in a petition, page number lordship 7. Relevant person, your lordship will find a place. Lordship,
13?
Page 8 lordships, my petition.
No, there's page number 13 is the vernacular.
Page number 13 is the vernacular lordship. Yes.
On the basis of one FIR lost by one Bipin Kolita of Khatri PS on 30/1/2024. The essence of allegation in the FIR dated so and so is that on 29/1/2024, while he was attending patrolling duty under the area of Khatri PS at about 9:40 PM, they have intercepted one truck bearing registration number NL01AD 3449 at Nolgadera Eleka. And found 35 numbers of cattle being carried in the same in an atrocious manner without any documents. Mr. Sutia, learned counsel for the applicant, submits that Guide order dated 28/2/2024, both the applicants were granted the privilege of interim periods pay. And thereafter they had appeared before the IO and they are cooperating with the investigating agency, and therefore a contention is being made that the interim order dated 28/2/2024 may be made absolute in the same terms and condition. Whereas Mr. P.S. Lawful, learned additional PP, submits that he has not received the case diary, but his instruction is that the IO has already completed investigation and submitted search sheet, being search sheet number 28 of 2024 dated 29/3/2024. Under section 11(1)(a), B, E of the Cattle Prevention of Cruelty to Animal Act, they do it section 13(1)(16) of the Assam Cattle Preservation Act against Habibur Rahman and Amin Nasr. Amin or Moin?
Should be
Moin,
Moin.
Moin Nasr. Moin Nasr and one Habibur Rahman. How many Lokor?
Rashid.
So you have mentioned.
Against three persons, Rashid.
What is the name of second person?
Rashid, both are same name, but some father's name are different. Rashid.
What's against one?
Habibur Rahman.
Habibur Rahman and another Habibur Rahman and
Habibur
Moin
Rahman.
Nasr. Since search sheet has been submitted after completion of investigation, this court is inclined to dispose of this application by directing the applicants to appear before the learned trial court and to apply for regular bail on or before. Kabir? 27. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, interim order dated and extended.
Online, Rashid.
Item 6.
Your Lordship.
Yes.
Moreover, it is that application where I had sought for my lord getting that stay order, my lord, which was passed by this honorable court, staying that investigation in the dispute police FIR, my lord. And a direction on the other day was passed, my lord, to produce the case diary along with the FSL report, my lord.
Yes, madam.
With this, your lordship, as per our instruction, the FSL report has already been sent to the IO of Dispur police station. Your lordship, 1 week time may be given. We will produce the CD and the FSL report together, your lordship.
Why 1 week?
Next
Dispur-
Tuesday, your lordship.
Next week.
Yes, your lordship.
Lord, can the matter be listed after 26th?
Why?
My lord, just yesterday I have been given responsibility by DALSA to conduct my lord, a session on the human trafficking on 26th June. That is why I'm praying, that is the matter may be listed after 26th.
Can it be
If
before,
possible.
before that, my lord?
I have the email, if it is required. Just yesterday, they have given the responsibility.
14th, right.
DALSA.
Can it be taken on the 18th, my lord?
No, I have no problem.
My lord.
I have no problem.
From 18th, my lord, 26th is long far away, my lord. It is another again, my lord, about 6-7 days thereafter. So on 18th, we can have it, my lord.
18.
I'll do it.
Okay. Third, Mr. G. Sodore, learned counsel for the applicant, and Ms. R. Gogoi, learned government advocate for the respondent number. Madam, you are for respondent number
One
and two.
1 and 3.
my lord.
And Mr.
I sing.
I say,
I sing.
learned counsel for the respondent number.
Opposite party 1.
Respondent number.
Actually, he is the petitioner, my lord.
I am the writ petitioner.
He's
my
the
lord.
writ
And
petitioner.
the IA am the
One.
opposite party number.
Respondent opposite party number 1. Ms. Gogoi, learned government advocate, submits that the FSL report has already been sent to the IO of the Dispur police station, and as such, she applies for 1 week time to produce the case diary as well as the FSL report before this court. However, on the request being made by Mr. Sodori, learned counsel for this applicant, it is provided that recessal is the matter on 18
18, my lord.
Tuesday.
18,
Okay,
yeah.
Tuesday. On that day, Ms. Gogoi shall produce the case diary along with the FSL report before this court.
My lord, in
My lord, can I pray for a direction, my lord, that on that day, the main petition may also be listed for admission and an effort may be made to dispose of that out also, my lord.
Lord, that is not for admission. It should be for hearing.
Because it is not admitted as yet.
Notice is
First, let
application.
us dispose of the IA, thereafter we will consider.
Then that, my lord.
Oblige, your lordship.
And it too.
So reasonable opportunity must be given to the other side also.
Yes, my lord. So that is why I said, my lord, on that only also, my lord.
For hearing.
My lord, the
item seven.
interim is there, my lord. The
Pardon?
interim may be extended.
Till then, interim order, first earlier shall continue.
Item seven, for hearing, order meeting.
May it please your lordship. On the last occasion, your lordship has asked for the around 313(1)(b). There is any explanation in the 313(b) statement. Para 22 I have marked 2028 SSC page 881. Para 22. Under the Code of Criminal Procedure and Sanitary, after the prosecution closes evidence and examining all its witnesses, the accused is given an opportunity to of explanation for section 313(1)(b). Any alternate version of the events or interpretation preferred by the accused must be carefully analyzed and considered by the trial court in compliance with the mandate of section 314. Such opportunity is a valuable right of the accused to seek justice and defend oneself. Failure of trial court to fairly apply its mind and consider defense would endanger the conviction itself. Unlike the prosecution, which needs to prove its case beyond reasonable doubt, the accused merely needs to get reasonable doubt or prove their alternate version by mere preponderance of probabilities. Thus, once a plausible version has been put forth in defense at a section 313 CRPC examination stage, and it is for the prosecution to negate such defense plea. And another one I got is 2001 10 SCC SCC 103 para 10. Second one. Last page. Para 10 last page. I mark it. At the trial, he has not supported the prosecution case fully. On other hand, the explanation given by the appellant both during the cross-examination or the prosecution witness and in his own statement recorded under 23 CRPC is quite plausible. When accused sets up a defense of or offers an expression, it is well settled that he is not required to prove his defense beyond a reasonable doubt, but only by preponderance of probabilities. Under prosecution own showing, in this case,
No, Mr. Gogoi, that is the legal proposition. There is no quarrel on this point.
the on the explanation
So
given by the accused.
what is the stand taken by you in the 313 statement
This is also
in the present case?
because she has abdominal ailment and in the 313 statement. Page 31, relevant.
34.
Page 34, question number 31 and question number 49. 31 and 49. PW further reports that he opined that cause of death was due to shock and hemorrhages as a result of hemorrhages inside the abdominal cavity.
No, now the question is, can the court act upon this statement without any document?
That is, if the accused given a reasonable explanation as for this judgment, Parminder Court.
Hmm.
The
No,
judgment,
that a reasonable explanation must be supported by any document. Where is the document that she was suffering from abdominal pain?
if our lordship see all the evidence of the prosecution witness, they have stated PW 1, 2, 3, and 5 has stated that the father-in-law of the victim has informed that she have died of abdominal pain. One, this is in all the examining staff. And second, also one, the independent witness has said that the elder brother was stated that she was suffering from ailment and died of death. If your lordship see the
No, you have taken a plea, that's all right, but you have to establish it by preponderance of probability, not by beyond reasonable doubt.
the defense created out because
But
they-
where is that evidence?
there is no
Where is that document?
because your lordship see there is no any external wound.
So can this omnibus statement can be acted upon and you can be acquitted?
No, I'm not saying that
Then,
that in the previous
Mr.
statements,
Gogoi, you please be logical. your only statement that my wife was ailing from long and she was also treated by her parents. And I have medical documents of her treatment. Where is those medical documents? Where?
The defense has failed, has failed to give the documents because the counsel who was
Then how can the court accept this plea? You take, you satisfy the court.
because,
How?
because in all the
No,
evidence,
no,
evidence of the,
no,
of the,
no, Mr. Gogoi, no.
I have
in the postmortem report also, there is no external found because it is of internal
No,
injury.
maybe, but
If there is no external note,
what is the opinion of the doctor?
because of lecture, rupture of the spleen,
Hmm,
and hemorrhage, she health died.
hmm,
If there is no any external note,
hmm.
the spleen may be ruptured. Last time also I have said the spleen may be ruptured because of some disease.
Hmm. So that is your presumption and your assumption.
No, in the postmortem there is no external wound as per the postmortem report.
Did you put any question to the doctor that without any external wound,
No,
can the spleen be ruptured?
no. Prima facie, if you see the postmortem report, your lordship, humble, there is there is no external wound.
Hmm.
If the postmortem report is seen, there is no external wound.
No, whether external wound is a sine qua non for establishing, no, for rupturing the spleen.
That is why I'm saying.
Hmm.
Maybe there may be a disease, as stated by the insurance statement. Also, the father-in-law
Maybe
said
because of disease.
disease because it
So
is-
we have to, you have failed to produce any documentary proof. And you are asking the court to presume that she has died out of this rupture of spleen
prosecutor put-
because of her disease.
No. See, the prosecutor has to
Then?
prove beyond reasonable doubt
Hmm.
because maybe she have died of some disease.
No, maybe it would
It
be.
creates a doubt
Hmm.
because as per the postmortem report, there is no external found. If I hit the victim, there may be wound in the externally, there may be some mark in the injury in the externally, but there is no external wound. So it creates a doubt. The prosecutor has to prove beyond reasonable doubt.
Yes, Mr. Locker, what is your submission?
Lordship, regarding that Lordship 313 statement, whether it should be accepted or not, Lordship, that I have placed one judgment, Lordship, like
Which one?
Lordship, Premchand versus State of Maharashtra. Premchand versus State of Maharashtra, Lordship. Here in Lordship, the first page, Lordship, third paragraph, Lordship. It is here. It is the covering line is Lordship. For instance, infects within the
Paragraph number?
first page, third paragraph, Lordship. Thereafter, I will come to that paragraph, Lordship. For instance, Lordship, first page, Lordship. Top of the page, Lordship. For instance, middle of Lordship. For instance, in fact, within the special knowledge of the accused are not satisfactorily explained, and that could be a factor
No,
against the accused.
para number?
Para 16, it will come, Lordship. The answer.
16.
And prior to that, Lordship, 16, para 15, Lordship, some guidelines has been framed, Lordship. What follows from these authorities may briefly be summarized as Lordship. The act, Lordship. The explanations that an accused may furnish cannot be considered in isolation, but has to be considered in conjunction with the evidence adduced by the prosecution. And therefore, no conviction can be premised solely on the basis of section 313. Here it says, Lordship, that Lordship, if the prosecution witnesses supports that his answer is supported with the prosecution case, then Lordship, it will be it may go against him, Lordship, even though it is he has discloses it in 313, Lordship. And Lordship, in para 16, Lordship, it is mentioned, Lordship, that bearing bearing the above well-settled principles in mind, every criminal court proceedings under clause B of subsection 1, section 3013 has to be shouldered the onerous responsibility of scanning the evidence after the prosecution closes its case to trace the incriminating circumstances in the evidence against the accused and to prepare relevant questions to extend opportunity to the accused to explain any such circumstances in the evidence that could be used against him. Prior to the amendment of section 13 in 2009, the court alone had to perform the task. Instances of interference with convictions by the courts of appeal on the ground of failure on the trial court to frame relevant questions and to put the same to the accused were not rare for turning up the criminal justice system and ensuring a fair and speedy trial with emphasis on cutting down delays. The Parliament amended Section 313 2009 in 2009 and inserted subsection 5, thereby enabling the court to take assistance of public prosecutor and defense counsel in preparing such questions. The first part of subsection ideally with such assistance which has to be real and not a sham to make the effort effective and meaningful. One would tend to believe that the courts probably are now better equipped with diligently prepare the relevant questions test lest there be any infirmity. Now it is important also. However, judicial experience has shown that more often than not, the time and effort behind such an exercise put in by the trial court does not achieve the desired result. This is because either the accused elects to come forward with evasive denial of answers questions with stereotypes like false, I do not know, incorrect, etc. Many a time this does more harm than good to the cause of accused. For instance, in fact, within the special knowledge of the accused are not satisfactorily explained, that could be a factor against the accused. Though such factor by itself is not conclusive of guilt, it becomes relevant while considering the totality of the circumstances. A proper explanation of one's conduct or a version different from the prosecution version without being obliged to the face cross-examination could provide the necessity, hint, or clue for the court to have a different perspective and solve the problem before it. The exercise under Section 313, instead of being ritualistic, ought to be realistic in the sense that it should be the means for securing the ends of justice. Instead of an aimless effort, the means towards the end should be purposeful. Indeed, it is optional for the accused to explain the circumstances put to him under Section 313, but the safeguard provided by it and the valuable right that it envisions if avail of
Object and philosophy behind the enactment of section 304B IPC. In this case, it has been mentioned that section 304B and the cognate provisions are meant for creditions of the social evils of dowry, which has been the bane of Indian society and continuous unabated. My lord, this is philosophy, my lord, why this section was enacted. And 42 also, my lord. The Dowry Prohibition Act also, the philosophy behind the Dowry Prohibition Act 1961, my lord. Therefore, my lord, a court may presume, my lord, if
That's
these
all right,
three
but this demand should be within a short period. Demand and death.
my lord,
Some other judgments are there where it is explained that this demand so made by the accused
my lord,
and the date of the deceased, the time of date of the deceased must
Right.
be a very short, and there must be proximate link.
in 2003 judgment also I have, my lord, I will provide it, my lord. Not in my hand, my lord.
2000?
to 2023 judgment, man.
Acha,
I got that in my.
You have that judgment?
I will provide.
okay. Then suggested that when can you release the matter?
Whether the judgment,
Next week. 25th.
whether that judgment is also that Balbir Singh judgment also.
Pardon?
Balbir Singh State of Uttarakhand judgment also, 2023 also.
I have not remembered it. I have noted it somewhere.
So it is also Indian Evidence Act lordship regarding section 106 lordship burden of proving facts, especially within the knowledge principles of law governing the applicable section. I will.
Maybe, that might be. He has also that citation. Confirm it.
I will also see.
You can also see. Okay, third, Mr. Gogoi, Learned Counsel for the appellants. Mr. P.S. Locker, Learned Counsel for the respondent number 1. And Mr.
M. Burman.
M. Burman, Learned Counsel for the respondent number 2. List the matter on 25th for further hearing.
Timing item 8. Give note.
Yes, Mr. Locker, you have gone through the record.
So on last occasion, lordship, P. Sharma appeared, and I have gone through the statement of 161 statement of the remaining witnesses.
Hmm.
And then lordship directed me to see whether the other remaining 161 other remaining witnesses there in their 161 they have implicated or not, lordship. That lordship asked me to, and that I have the knowledge, but I have not gone through the PWS lordship. On PWS on last occasion B. Sharma submitted lordship that no, he has not been directly implicated, but lordship in 161 statement lordship once or two witnesses have stated lordship, though they have not mentioned their name lordship, but two male person they have mentioned lordship.
No, have you, no, unless and until you can go through the evidence, so recorded, how can you submit? How many witnesses examined till that, Mr. Gogoi?
Not just 7. Out
Seven?
of 11, 7 only examined.
Out of 11,
Lordship.
three, there remains 3.
Remaining only 4.
And out of 7, according to you, none of them implicated you.
Against the petitioner.
Mr. Locker, you go through the same record, you appraise this court on Tuesday.
Tuesday or
But
Monday.
you ensure that on that day you will appear in this matter. Unless again someone will appear and you will tell that I have not gone through the record.
Okay.
On the pair being made by Mr. Locker, learned additional PP. Recess and list the matter on Tuesday.
Highly
As part of-
honest.